health and safety, health. I never know what comes first because it's SHC. Do you now have access to the delete notes? I did load them because I realized that they had been loaded for the CLA class, but not for the health and safety class. Have you tried accessing them? Okay. No one seems to know. Any questions with regards to Introduction to Contracts Law and DILICT before I move onto the JBCC? No questions? Okay. I most certainly have questions for you in the test, so all good. There was a question about the test that had been loaded. Gives a bit of an indication of what the test will look like, but your test will be a little bit longer than that. There'll be a little bit more reading to do. Okay. So yeah, that was a quiz from I think 2 years ago. So we're doing the JBCC contract. It is a South African contract. It's the Joint Building Contract Committee. That's what JBCC stands for. We will deal with the latest JBCC edition or the latest agreement, which is the JBCC 6.2, that is currently in circulation, currently being used by industry. Okay. The learning objectives. This you most probably have done JBCC before, probably in the 3rd year, because I think our introduction as well as students to contracts law, we did the JBCC, and then the other contracts, the engineering contracts followed in the 4th year. However, like I say, because this course sort of accepts people from different backgrounds, different areas, the first 2 parts of the lecture is just to put everyone on the same footing. So for those of you who've done JBCC, you may find this a little bit boring because you know about the JBCC. However, just bear with me. There are people who have not done it, okay? Or who have had no experience with it prior to this, okay? Or who have not used it in a while and who have forgotten it. So and this is why we will run through this quickly. It's not a long contract. You will, once you've done this with that class, you should be able to identify the important role of JBCC documents in the SA building industry when they apply. I think somebody asked me, how do you know which contract to use? I think at the end of this, you should know when to use the JBCC, when would it be applicable and when not. Taraz, you have your hand up? And then you took it down.
It was me who asked.
Oh, okay. Oh, yes. So yeah, like I said, I just remember there was a question. So this is the whole idea. You'll know when to use the JBCC, understand who the principal agent is and what their duties are. And this may differ depending on which sector. So in the public sector, the powers of the principal agent are curtailed a bit, whereas in the private sector, they have a little bit more leeway in terms of making decisions. We have a JBCC suite of documents. So you have the minor works and then the principal building agreement. We have I think there's about 3 of them. And then we have the nominated and selected subcontract. It's also part of the JBCC. So this is a bit of background, a bit of history, neither here nor there. It's not going to be in the test. Because of the way my brain works, I need to place something in some context. So generally, I will go into the historical context of it. So there was a JSC, Joint Study Committee, that was established in South Africa around the 1970s. Okay, please just ensure that you're muted.
Good evening, ma'am. I'm not sure if you're aware, but you're muted right now.
Oh, okay. In my attempt to mute somebody, I may have muted myself. Sorry. All right. So, like I was just saying, I just give a bit of background to the JBCC, just so that well, it's not for test purposes. I'm big on understanding where things come from and how we ended up here. So maybe I should have followed history in my life, but I didn't. So you are here doing the history lesson with me. Just for the part of the JBCC. So like I said, there was the JSC committee, the Joint Study Committee that was established in 1970. So this was around a time when the industry decided they need a local building contract, because I think they were using, I think it's the JST from the English, and it wasn't quite working for the South African system, and they wanted their own, but unfortunately the JSC failed to produce a local building contract. And then in 1984, they established the JBCC, so Joint Building Contract Committee. And from 1984, they were working on something. And then in 1991, they released the very first JBCC edition. And then around 1998, they released updated documents. So you know what happens is they release an edition, they give it to industry, and then as you're trying to implement contract running projects with it, you encounter problems. Then you write back to the JBCC to say, what did you mean with this clause? What? And that sort of feedback is what creates a need for an update. Okay, so if there's any ambiguity, whatever it is that is identified, and then maybe court cases as a result of using that contract, and then with the next edition they try and iron out whatever issues or ambiguities that were in the first edition. So in 1998 they released that second edition, and it was called the 2000 edition. I don't know where people were, but leading up to the year 2000 was this big millennium thing. We all thought the world was coming to an end and stuff. So everybody was updating everything to match the new century, the new millennium. So it was the end of a century, the end of a millennium. So we were introduced to the release of the updated documents, the 1998, the 2000 series. The whole idea was for it to meet the needs of the public and the private sector, because then you have the public sector, which is government, the Department of Public Works, as your biggest client, as the construction industry, because they have the biggest budget when it comes to infrastructure. Okay. And this edition replaced all documents of 1991. Didn't last long, 98, and then in 2003, there was a third edition released, and part of the reason was the state attorney, so the people who represented the public sector, were not happy with the public sector clauses in the 2000 series edition. So then the third edition was released in 2003 with a lot of focus on clause 13. So clause 13 dealt with state clause. It was a state clause, so it dealt with contracts with the public sector. Again, the state attorney was still not happy with the changes that had been made. And then in 2004, the fourth edition was published. They also introduced adjudication as part of the alternative dispute resolution, so ADR. And then clause 40, which dealt with alternative dispute resolution, was completely redrafted. Again, clause 13, which deals with state issues, was also updated. Then in 2005, edition 4.1 was introduced. So what they do is all the professionals are represented with the JBCC. So the ASAQS will nominate somebody to be on the JBCC board, one of their members. Their job is to make sure that quantity surveyors are represented and their interests and all of that. Remember when we were talking about these type of contracts and how they try to distribute risk equitably. So the quantity surveyors, the architects, the project managers, the professionals, and even the contractors, and then the state also. I think SAPOA as well, the property. They don't have a seat as such, but they are allowed to, they don't have a position, but they're allowed to be a part of it as the clients. So when they reviewed edition 4, it was decided few changes again, then it became edition 4.1, which was introduced in March of 2005. Then clause 13 was changed to be made clause 41, so the last clause. And then adjudication was reviewed, and the agreement was it would be the default dispute resolution process in private contracts. So the state can decide, the state usually, so if you have an agreement with government, their default dispute resolution process is litigation, which is you're going to end up in court. So they will take all matters to court. Generally, that was what used to happen. Now we're seeing a lot of them defaulting to adjudication. It's a lot cheaper. If you are taking a contract dispute to court, chances are you will be getting a date for 2030. If it's a project that's running, you don't have that time. So court processes take long and they're very expensive because now you have to brief senior counsel. So there's like a lot of lawyers involved. They're charging you per hour and all of that. So it's not a quick fix. Then in 2007, the 5th edition was published. And from 4.1 to the 5th edition, the private sector was not happy with certain clauses. There's also, if you think about your bill of quantities, Section 1 of the Bill of Quantities is your preliminaries, which speaks to the contractor's overheads. So things like the site office, contractors traveling, salaries for his admin people, head office costs, all of that sits in your preliminaries. The toilets on site, all of those that you cannot price in square meter or in volume, cubic meter or number and all of that, they go into your preliminaries. So the Association of South African Quantity Surveyors prepares the preliminaries based on the JBCC edition that's in circulation. And so the 4.1 and the preliminaries, there was an issue. And so then the idea was let's incorporate the preliminaries as part of the principal building agreement, which is that PBA there. There was also redrafting of insurance clauses. So clause 10 and 11 speaks to works insurance, third-party liability insurance, all of those lateral support insurance. So they redrafted those because now looking at the liability that the contractor is exposed to or the client, who takes responsibility. And then also what was in discussion was contractors' right to suspending the works. That was introduced as well. Schedule of variables for the contract data. And then security provisions, adjustment of security provisions to align with those of the state. And then they removed adjudication as the default dispute procedure. And they said the parties to a contract can choose. What happened here was that the CIDB and the state attorney, so the CIDB usually represents government, they sort of didn't come to the party. And then edition 5 didn't have state clauses. So you will find that a lot of the projects that were done after 2007 in government were still using edition 4.1 because it had state clauses and edition 5 didn't. Okay. So in as much as it had a very long run because the private sector was quite happy with the 5th edition of the JBCC, the state could not use it as it didn't cater for them. So we had to move on to edition 6 in 2013 from 2007 to 2013. However, it was retracted. There's a story behind why it was retracted. I'm not going to share it because I'm on record and I don't know if the story is true or not, but there was a mishap with the edition that was sent to the entire committee as edition 6. The person sent the draft and not the actual final document. And then they had to, when he issued the final document, when he corrected the mistake, it now had to be 6.1. and it was published in March 2014. Didn't have state clauses as well. This one, the industry rejected. Industry was not happy about it. So the JBCC scrapped it off altogether. It even, I think there was a lot that happened there. I think the JBCC CEO even resigned. You know, it was a huge, monumental mess. 6.1, but it was later scrapped off, and you won't even find a copy of it if you never got it before. So when you go into JBCC documents, it's not there. We moved from edition 5 right to 6.2. So then 2013, 2014, 2015, 2016, 2017, no JBCC. And then in May 2018, they released edition 6.2 again. When it was released, it didn't have state clauses. They have been added. And again, the ASAQS continues to publish preliminaries to cater for, which also caters for the clauses that are not accommodated in the JBCC. So the constituent members of the JBCC, you have the ACPM, Association of Construction Project Managers, Association of South African Quantity Surveyors, CESA, Consulting Engineers South Africa, Master Builders South Africa, South African Black Technical and Allied Careers Organization, which is SAPTACO. You have the Institute of Architects, you have Property Owners Association, you have SEC, which is Specialist Engineering Contractors Committee. So those are the constituent members. I had said SAPOA doesn't have, they actually have a permanent seat. I was not right there. So SAPOA also sits there. The CIDB also sits, even though they don't have like a seat like those, but they come in and they're part of the JBCC, or they form part of the sittings. And when it comes to state clauses, it's meant to serve the Department of Public Works. Or the Ministry of Public Works. So the objectives behind the JBCC was to foster good and consistent management of the project by all consent, provide standardization, define terminology, so that they can eliminate ambiguities in interpreting whatever is said in the contract. So the idea was use simple language, and so that everyone who reads a clause understands it the way it was meant. They also clearly define and identify responsibilities of the contracting parties, you know, what the client, the employer, when I say client, I mean employer, what the employer does, what the contractor does. Those are the two contracting parties. It defines the notice periods, time bars required to protect either of the parties against prejudice or error. So the contractor, if he notices something that needs to be corrected, he has a notice period that he has to raise this by. If that passes, then he sort of loses that chance. Same goes for the client with certain things. Also, the objective was to promote contractual protection of the innocent party in the event of a default. So if the other party decides to act in a manner that was not contractual, provide practical options within the contracting process, reciprocal guarantees between the contracting parties so that none is left at risk, set payment conditions that offer significant protection to the contractor and to the subcontractor. So if you think about building contracts in the way that we spoke about, where you have the client being responsible for design and the contractor being responsible for construction, in that relationship, the biggest risk that the client has is non-performance by the contractor. So if you are a public entity, let's say the Department of Health, and you've entrusted Public Works to build you a hospital, they appoint a contractor. The biggest worry is this hospital should be finished. You know, the contractor should be able to conclude the job. In the event that he can't, you need some guarantee, you know, some way of ensuring that he performs. So a performance guarantee. For the contractor, biggest risk for him is, what if I do the work and then I don't get paid? Because remember, they commit money to a project and then you pay them after. So they do work, they get paid, do work. So that means they commit money first and then they get paid for work done. Commit money. So what happens if you commit money and then there's no payment? So in the same way, they require a guarantee from the client a payment guarantee. So they will give a performance guarantee. The client will give a payment guarantee. Then there's like payment conditions that are set by JBCC standards. The contractor should be paid on a monthly basis. So the quantity surveyor will do an assessment and issue monthly payments or payment certificates, interim valuations every month. Whether the contractor submits a claim or not, the quantity surveyor has a responsibility to issue a payment certificate every month. So the month is a minimum. The contracting parties could agree that they will pay every 2 weeks, depending on the size of the contract and the needs of the contract. But at a minimum, you pay at least monthly. Okay. And then you ensure the objective was also to ensure maintenance of the independent duty of the principal agent to act fairly between the parties. So the principal agent is appointed by the employer to represent the employer. So it could be back in the day before project managers were a thing, the architects as the lead designer would be the principal agent. In as much as they are employed by the employer and they get paid by the employer and they represent the employer, there is an expectation that they have to be objective when discharging their duties. They have to discharge their duties as a professional. They have to be fair. So they can't take the employer's side only because the employer is paying them. So the way the contract is structured is also to ensure that the principal agent's independent duty is maintained and he's not compromised in any way. So those are the principal features. You can read through them. Government contract standardization, simplification, implementation guides, all of that. You can also go onto the JBCC website and look at these things if you want to see. They do have examples if you need any. So the principal building agreement is what we will be looking at. Remember I said there's the nominated selected contract, there's the minor works agreement, there's also for small works, there's the small works agreement as well. We are going to focus on the principal building agreement. It is the backbone of the JBCC suite of contracts. And if you understand the clauses there, it should be easy for you to understand the other clauses. Okay, so I'm not going to look at the other ones. You can read through them. I do share the copies within the notes, but we're going to run through the principal building agreement. There's also the adjudication rules in the event that parties opt for adjudication as their default dispute resolution method. So this is what happens when there's a dispute between the parties and the contractor says one thing, the employer says another, and for some reason they cannot find common ground. That becomes a dispute. So they try to solve it themselves first, and if they can't, then the aggrieved party will declare it a dispute, and they will follow the alternative dispute resolution method. So if it's adjudication, then the matter would be taken for adjudication. Okay. And then there's a document called Waiver of Contractor's Lien. We'll speak about it when we talk about securities or guarantees. That's where it comes. Then we have the payment guarantee, which is required if you're using the principal building agreement and the nominated or selected subcontract agreement. Okay. Then you have the advance payment guarantee. This is the guarantee that the contractor would give to the employer in the event that the employer has to give the contractor a payment advance. So sometimes you find that there's work that needs to be done and there's significant stuff that needs to be bought and it has a lead time. So an example would be when we built the Stats SA head office just right behind Pretoria Station. They had imported furniture for the pause areas. And because they were ordering big quantities, because that's a huge office complex, the manufacturer said, okay, it's going to take us so long to manufacture. and they wanted them in the colors of Statistics SA. I think it's blue and I can't remember, but it was like shades of blue. So then the contractor has to place an order for that. And you find that it runs into millions. And this is money the contractor doesn't have or they can't commit initially. So the client will say, okay, we'll give you an advance of that amount. Then we deduct it from your payment. So when you get, let's say they give the contractor 5 million. And then when they pay him his first payment, he does work for about, let's say, 2 million and they deduct 500,000 from there, and then it goes towards the advance until the advance is fully paid. The contractor gives the client something called an advance payment guarantee. This is a guarantee that he would get from a financial institution. It's the employer's insurance that should the contractor run away with that advance payment, the employer can go to that financial institution and claim his monies from them. So the guarantees should be liquid. As soon as the contractor submits his claim and gives the evidence, he should be paid. No stories, nothing. So what happens is the contractor will go to a financial institution, get this guarantee, and then what they do is then they will pay a premium every month towards that guarantee. And then as it reduces, then the premium will also reduce. Pal, please switch off your video. Thank you. So that's what an advance payment guarantee is. Then you have your deposit guarantee. This only happens in the minor works contract. We don't have that in the principal building agreement. Then there's the construction guarantee, which the contractor will give to the employer to say in the event that I don't perform, you can claim from this guarantee. So you have it for the principal building agreement, nominated and selected subcontract agreements, and in the minor works agreement. In the small works, not so much. Then there's the certificate that we give to the contractor when we hand over the site to him to say, this is your site now, site possession certificate. Then there's payment certificates, those that I said at a minimum, you issue every month. You have your recovery statements, which come with your payment certificates. And this is if there's money to be recovered from the contractor, or there's, especially in the event of an advance payment, then we reflect that on a recovery statement. It doesn't go into the certificate, it goes onto the recovery statement. This is something you would have probably dealt with in economics if you did certificates in second or third year. Then you have the certificate of completion. So completion is split into practical and final completion. So there isn't one certificate. You get certificate of practical completion or certificate of final completion. And then there's the minor works agreement guide to completion in terms of how you deal with completion at minor works level. Adjudication rules, and then your SAQS preliminaries, which will go into your bill of quantities. So when you look at the JBCC contract, it's divided into 8 parts. So you have clause 1 to 7, which is your interpretation clauses. Okay, so clause 1 would be like your definitions and all of that, what is meant, how we communicate up to clause 7. This is why those are your interpretation clauses. Then 8 to 11, that's insurances and securities. And securities that deals with your guarantees, advance payment guarantee, construction guarantee, payment guarantee. When do they apply? How do they apply? When is the contractor expected to submit? When do we give them back to him? When, the employer and all of that. Then the third part is your execution. These clauses from 12 to 17, they speak to how the contract is executed during construction. Then 18 to 24 has to do with completion. The payment clauses, clause 25 to 27. And then you have suspension and termination. So clause 28 to 29, 28 deals with suspension. Who can suspend the works? When? Why? How do they undertake suspension? What is the process to follow when you suspend the contract? Termination. Who can terminate? Under what circumstances? And how should that be handled? Okay, then you have clause 30, which deals with your dispute resolution. So all in all, we have 30 clauses. And the last part would be your agreement. So that would be like your contract data with the details of the parties, the addresses, and all of that. Okay. So if you go on to clause 1 of the JBCC, they have the definitions of the words. So any word as you go through the contract that is in bold type, so any word that is bolded in the agreement has a meaning that is assigned to it under the definitions clause. So when you go to the definitions clause, they're listed in alphabetical order. And it will give you working days versus what working days mean by JBCC standards, what calendar days mean, what the budgetary allowance is, price document, bill of quantities, final payment certificate, practical completion versus final completion, contract sum versus contract value. All those things are defined. When they say agent, what do they mean? What is an agreement? Bills of quantities. So any word that you come across with when you're reading the clauses and you're not sure, you can't give it your own definition. If it's in bold type, you check under the definitions clause to say, okay, what does it mean? What is default interest? What is considered a defect? What is considered construction information? What is a direct contractor? What is employer? What is final account? All of those things. What is meant by free issue material, latent defect, list for final completion, all those things. So you can go through those definitions in your own time. I'm not going to go through them with you. So I've given you an indication so you can look at it. What is a budgetary allowance? And then what is a provisional sum? Because these are things you would use in your bill of quantities. You have provisional sums. How do they apply? And then a budgetary allowance. What is a prime cost amount? All those things. You find these definitions in clause 1. What is considered a force majeure event? So this is one of the clauses, I think it was in edition 5 where it was taken out, force majeure, and then they brought it back with 6.2. But if you've done like commercial law, and you were doing that contracts law, you know what a force majeure event is. So an event that neither of the parties could control, but would have an impact on the contract. So an exceptional event or an exceptional circumstance that could not have been foreseen by either party is beyond their control and could not reasonably have been avoided. I mean, if you cannot foresee it, how do you avoid it? Or how do you overcome it? You plan for things that you think will happen. And if this is not something, so then it becomes a force majeure event. The examples are like acts of war, whether war was declared or not, an invasion, or hostile acts of foreign enemies. An insurrection, rebellion, revolution, military or usurped power, and terrorism. Civil commotion, disorder, riots, strikes, lockouts by persons other than the contractor's employees or his subcontractors. So you could find that, let's say the taxi drivers are on strike and then they shut down the entire city and your site is in town. That is something you could not have foreseen. That is something you have no control over. It's just taxi drivers having decided to shut down the city, and that means you can't access site and you can't work for however long that strike is. Okay, so that could be an example. Sonic shock waves caused by aircraft or other aerial devices, and ionizing or radioactive contamination, explosive materials, except where those materials are attributable to the use of such technology by the contractor. So if it starts raining explosives and it's not the contractor trying to break hard rock, and then natural catastrophes like your earthquakes, floods, hurricanes, volcanic activity, none of us know when they are going to happen when you plan a contract, especially because building projects take long. Okay. Then you have, I think, your guarantees, advance payment guarantee, and then construction guarantee, which are like part of your securities. We have also payment reduction, generally called retention, but JBCC moved from the word retention to payment reduction because apparently it created an expectation from the contractor that if you retain some of his money, surely you're keeping it in an interest-bearing account. So then the wording was changed to say, no, actually, we're not retaining your money. We're just reducing your payment by a certain amount, which we will give back to you at the end of the contract, just to ensure that you will do work. Then you have default interest versus interest. Default interest is what the contractor gets. So whatever the ruling rate is by JBCC standards, if you delay paying the contractor, and let's say the prime lending rate is 14, okay, what is it now, 9%? I don't know what it is. Yo, let's say it's 9%. JBCC says to whatever the prime lending rate is at 6%, and that's the default interest to the contractor, because as the client, your job is to pay. So you can't be passing on your money matters to the contractor. So if you delay paying the contractor, then he's going to charge you that interest, that very high interest, prime plus 6. Then interest is what the client would be entitled to if there's a delay, which is sort of the bank rate applicable. So your prime lending rate is what would be used in the event of interest. So, and it's calculated each calendar day of the month. It's compounded annually. So again, economics comes in handy here, where you did time value of money and you are calculating and you know what compound is and how we compound monthly or annually and stuff like that. So that prime lending rate is an annual rate. Then you have your defects. You have latent and patent defects. Your patent defects are the ones that you can see, you know, when the contractor is done and say, I'm reached practical completion or I'm about to, and you can walk around the site and point at them. Those are your patent. Latent are the ones that will show much later. You know, the contract, maybe a week later, maybe a month later, maybe a year later, the wall starts to crack. And then you call the contractor back to say, sorry, sir, please come and fix the mess that you made. So that's about clause 1. Clause 2 deals with the law, regulation, and notices. So it's about 4 subclauses, 2.1 to 2.4. And it sets out the law to be complied with and how notices should be handled. So basically, the contractor will comply with the law of the country where he's implementing. He will obtain permits, licenses, and approvals that are required by law and pay the related charges for the execution of the works. So for instance, your construction permit, you know, before the contractor starts, and then he has to issue a notice to the Department of Labor, and then they give him a permit to proceed, that sort of thing. So that's part of the law. It's not a JBCC contract issue. It's a matter of legislation. So remember when we said your contracts have to be legal by whatever the law of that country that applies. So again, that's the law of the country. So any approvals, any permits that and licenses that the contractor needs to get before he proceeds with the work, he must do that and pay for it. Okay, so these are covered in his preliminaries because these are things that are going to need to be done. And then the employer as well will comply, shall, not will. It's not a matter of choice. They shall. They must comply with the law. They will also obtain whatever permits that need to be obtained by them. So during the planning, any building or similar permissions, they must pay charges for the works other than those which are the responsibility of the contractor. And then all communication notices between the parties, and here the parties is the employer and the contractor, will be, or they shall be, in the language of the agreement. So the agreement is in English, notices should be in English, all right? And in a format that can be read, copied, and recorded. So all notices or communication written, okay? Because you want it to be read, want it to be able to be copied, and that it can be saved somewhere, okay? So that is the format that communication or notices should be in. So if there's any legal processes that arise from this agreement, they have to be delivered to and served on the parties at the physical address. So remember, we said at the end of this document would be your contract agreement or the contract data where they will put their details. So if I put my address at 18 Research Marshall Street and I don't update it and I don't change it, if you need to serve me as a party with any legal notice, you would deliver it to that address, okay? However, either party may change their contract by notifying the other to say, look, I've moved from 18 Risik, I'm now at 63 Fox Street, or whatever, you know, so you can change, but you have to still be in the same country. I can't move to Namibia and expect you to deliver notices there, okay? So all notices given in terms of this agreement will be deemed to be received if it's delivered by hand on the day of delivery. So when I deliver the notice and I give it to you, or I give it to a representative of your company, then it's delivered when I give it to you. If it's sent by email within 1 working day, so electronic mail is excluding social media. So WhatsApp is considered social media. So 1 day, so you send the email today, you give me 24 hours, all right? So tomorrow you deem it received, because then you've given me at least time to look through it. Generally, with some contracts, people change this clause to say electronic mail within 2 days, so that they give themselves time, because you sometimes find that you're very busy. Then you have registered post, which we no longer have in South Africa. Post office shut down. We now renew our licenses there, the few offices that are still open, but registered post would be within 7 calendar days. So calendar days would include Saturday and Sunday, whereas working days would be your Monday to Friday, okay? Then clause 3 deals with your offer and acceptance, the agreement, okay? What is the objective of the agreement? The execution and payment of the works. So there has to be like an offer by the contractor, and then the employer accepts it. It will also state the currency of the agreement. Are we dealing in dollars and South African rands? And you know what happens generally, we deal in the currency of the country generally, but there are times where you find that things are not stable, currency is volatile, so then you use a more stable currency for that, but it would be stated in the agreement. And then the agreement itself, the contract itself, comes into force on the date of acceptance by the employer, and then it continues to be in force until the end of the latent defects liability period, unless the contract is terminated or the certification of final completion and final payment. So should any provision of this agreement be unenforceable, the parties are expected to act in good faith and to agree on alternative provisions in terms of the agreement. Okay, so I think we spoke about subsequent impossibility when we did introduction to contracts law. So should at some point something like that happens, like certain things become unimplementable or unenforceable, then the expectation is that the party will engage and act in good faith. Don't see it as your chance to run away with somebody's money and stuff like that. So good faith is expected to the both parties so that they can find agree on an alternative provision. So failure or omission by a party to enforce any provision of the agreement shall not constitute a waiver of such provision or affect such parties' rights to require the performance of such provision. So if you fail to, let's say, claim something at the time that it's supposed to, it doesn't mean that you've waived your right, okay, to require that particular performance. Then clause 4 deals with cession and assignment. So this is where a party cedes or assign their rights or obligations under the agreement without prior written consent of the other party. So for instance, we've agreed that you'll build me a house, and I will pay you. However, Mpo owes me money. So then I now decide, well, you can build the house, but you will collect your money from Mpo. You know, that's my obligation to pay you. I'm now assigning it to somebody else or ceding it to somebody else. So that can only happen if I give notice to you prior a written agreement to say, okay, please note that at the end, when you need your money, you will collect it from, and you agree to it. If you don't, then our original agreement stays. And the contract or the agreement, the JBCC contract states that that agreement by the other party shall not be unreasonably withheld. If what I'm saying makes perfect sense and it's reasonable, there's no reason for you to just refuse because you can, okay? And the contractor also shall not consent to a nominated subcontractor ceding rights or assigning rights and obligations under this agreement without getting prior written consent or prior written approval of the principal agent. So if your nominated or selected subcontractor wants to cede their rights, the principal agent is to be notified, and then they have to agree to it. Not just notification, they must also consent. So 4.3 says, notwithstanding the above, so what I've just explained, where party cedes any right to any monies due or to become due under this agreement as security in favor of a financial institution, consent shall not be required, provided notice as such of such session is timeously given to the other party. So let's say you're a contractor and you owe SARS, and then SARS finds out that you're doing work for me and they want their money. And they say, and then you say, okay, I'm doing work for this person. When the time comes for me to pay, to be paid, that money should be paid to you. So there, I'm not at risk as such. The only thing is when the time comes for me to pay, I will not pay it into your account. It will be paid into the financial institution's account, provided notice was given on time. Okay. So we had a consultancy company that owed SARS, and SARS started giving letters to all the companies where this guy had done work, and we're saying, please note this person owes SARS. Do not pay him before you pay us, you know, type of thing. However, well, as a state institution, we couldn't pay him anyway, because for us to make payments by law or by treasury regulations, the people being paid should show that their taxes are in good order. So they give a tax compliance certificate. So obviously, if you owe SARS, you would not have that. Okay. Then clause 5 deals with documents. Ooh, okay. I don't know why it's not included here, but yeah, clause 5 deals with documents. You can read through it. It has 6 subclauses. So when we say documents under this clause, we mean all the documents that I refer to in this agreement. So the current edition with all the amendments there too. So if the client makes any amendments to the contract or anything that was submitted with the contractor's tender and accepted. Sometimes when contractors submit a tender, they submit it with qualifications, and it's up to the employer to accept the qualifications or reject them. So let's say it's accepted with the qualifications, so that part of the document will be those qualifications. and the parties will sign the original agreement. And then each party will get a copy of the agreement. And then the original agreement is held by the principal agent. So you sign one document, principal agent makes copies, 2 copies of that document, gives one to the employer, another one to the contractor, then he keeps the original signed. So in the agreement, it will also state the people who are authorized, so persons, so whether it's persons as human persons or juristic persons who are authorized to act on behalf of either party. So the agents appointed by the employer will be identified under the construction information. So if you go into your bill of quantities and you go into your preliminaries, you will see there's that. They're listed there. And then those authorized persons may be changed by notice to the other party. So if you've appointed me as your quantity surveyor and then I win the Powerball and I'm like, sorry, I'm going to stop working. I'm going to run around the world chasing summer. Please find another quantity surveyor. The employer would be obliged to notify the contractor. Please note, Mabatwana and Associates is no longer going to be our quantity surveyor. We've appointed QS3 quantity surveyors or whoever, so that sort of thing. Then your price document, whether it's the bill of quantities, the schedule of rates, whatever price document that is being used, that price document cannot and shall not be used as a specification of materials and goods or methods. So your bill of quantities, so if you are, your specification says, whatever, 20 millimeter thick Meranti sketting, and then your bill of quantities speaks of clear pine sketting. You look at the quantity in the bill of quantities, but the specification is what is given by the architect. So the priced document is mainly for your quantities, not for specification. Okay. So in the event that there is a clash between the bill and the drawings take precedence. And this is where it comes from. Okay. Subclause 5.4, which says the price document shall not be used as a specification of material and goods or methods. And then the contents of the agreement shall not be published or disclosed or used for any other purpose other than that specified in the agreement. So you can't take this agreement and use it for other things. It's meant for the job. And if you're going to use it for other things, so let's say it becomes something that a student uses for their assignment, you'd have to notify the other party when you agree to it. It was okay, fine. You can look at this. You notify the other party that it's going to be published or used for other interests. And then another thing with documentation is the contract needs to stipulate or specify when the principal agent and the agents shall provide copies of drawings, unpriced bill of quantities, and other construction information at no cost to the contractor. So there's copies that should be given to the contractors, copies of construction drawings, construction information, and all of that. And then beyond a certain amount, so usually it's 3 copies, and then beyond that, the contractor would have to pay for other copies. But you specify in the contract itself to say there'll be 2 copies of everything for free. Anything beyond that, we will charge you. Okay. Then clause 6 speaks of the employer's agents. Okay. So you have the principal agent who has the full authority and obligation to act on behalf of and bind the employer in terms of this agreement. So he has no authority to amend the agreement. So if the agreement is we're building a school, he can't change it, okay, to a clinic or something. Like he can amend the contract, but he has the full authority and the obligation to act on behalf of and bind the employer. So for whatever reason, if we've agreed on 5 millimeter thick chromatic roof sheeting, And the contractor comes back to say, you know, Chromatec doesn't make that 5mm anymore. They're now making it at 3.5mm. This is the performance, whatever. The principal agent can say, okay, fine, go ahead, procure the 3.5mm, you know, type of thing. So he can make such decisions. So for those who are working, you know, with your, what are they called? Cost report meetings or cost report presentations by the quantity surveyor, where it's like, okay, we've saved so much here, but then we need money there, and then they move money around. The principal agent sort of authorizes that, okay, no. And then we go to the client if we need additional money. So this is if you're dealing with private sector contracts. Government, the principal agent is just an administrator. He can make recommendations, but not decisions. Okay, so you find that the contract is modified and that the final decision has to be made by the representative identified by the public sector. I work for government. In my case, all decisions, and with most departments, are relegated to, or at least escalated to the head of department. So it could be something like, okay, we've we need. All the principal agent can do is comment to say, I've checked, the contractor has priced as per market. This is fair. Please approve so that we may proceed, you know, and then the client will look at it and approve and then proceed. So that is the slight difference with the private sector. Maybe it's not slight, it's a huge difference with the private sector and the public sector, in that the principal agent would not have full authority. He has partial authority to act on behalf and bind the employer. So the principal agent cannot bind the employer. You find that he agrees to something, then the employer comes back and revokes it and says, I would never have agreed to that. There is an old case from the 1800s. I forget the name. I was also told about it as a student. And every year I think I'll remember what it was. However, what happened is the old lady was having her house built, agreed with the architect, the principal agent, what should happen. And then she left to go on holiday, left the project running. And something changed in terms of, it was a renovation to her house, demolition. So I think they were supposed to demolish a wall. And when the contractor was supposed to do that work, they realized that it's going to collapse the roof structure or something. So he needs to provide a certain level of support. So initially it was just create an opening here, demolish this wall to create an opening. And he never thought he would have to reinforce the walls, or at least the top part. So when he realized, he said to the architect, actually, I'm going to have to put a beam across and then a column here so that the structure doesn't collapse, but you still get your opening. And the architect said, okay, fine. The principal agent, how much is it going to cost? Costed it, told him. Principal agent said, go ahead. Contractor went ahead, did the work. Afterwards, old lady came back from her holiday, house was done, she was very happy, right? Like, yeah, beautiful, I like it. And she was told, oh, by the way, we had to improvise here and put in additional support, and it came at this extra cost. She was like, I never agreed to that. You gave me a cost and I said, go ahead. Now you're telling me about additional monies I'm not going to pay. I didn't authorize that. So the contractor took the old lady to court to say, but this was your house, this is, you know, and so like I say, it's an old case. And when I'll just ask one of my former classmates and then just find it, and then you can read it, because I don't even remember the merits. It was so faded on that document. Hopefully somebody has retyped it. But in the end, the contractor lost the case. So this was money he had put into the contract, and he couldn't get paid. The court said, you can't hold this poor lady responsible for that money. She was not there. She didn't agree to it. So now when you look at it, there is no contract between the contractor and the principal agent who instructed him. So it's not like he can just take the principal agent to court and say, this guy said I should do this work, therefore he owes me. The contract was between him and the old lady who wanted her house renovated. And now you ask yourself, what recourse does he have? Because now he's lost in court and like, sorry, sir, that money you spent, this lady's not going to pay it. She's just told you she doesn't have it. You should have waited for her to come back and tell you that you can proceed. Which then seems unfair. By that time, the principal agent has made his fees and he's walked away from this. So the contractor is the aggrieved party in this instance. Okay, so you think about what would be his recourse in this instance. What chance does he have of recovering his money? I'm not going to tell you. I'll ask you this in a test and then you can think about it. Okay. Then clause 7 deals with design responsibility, where the employer is responsible for the design of the works. And then if the subcontractor has to design something, the engineer signs off on it, and that responsibility devolves onto the employer still. So even if it's a subcontractor design, it's approved by one of the client's agent and it doesn't devolve to the contractor. So the contractor will just design his temporary works, those temporary hoardings where the gate is going to be the access gate for his people, where the side office is going to sit and the toilets, and that those temporary works would be his designs. But anything else, in terms of JBCC, the employer is responsible for design. Okay. I kind of want to stop here because I've been talking for a full hour, and ask if you guys have any questions, and then insurances, and then the execution clauses, and then lastly we'll deal with payment. So next week what I'll do is I'll do 45 minutes. Tarazelo, I see your hand is up. What is your question?
Good evening to the class and to yourself, Prof. I just wanted to ask, with the previous example that you had given, what would be the correct steps that the contractor would take in a situation of that nature?
But I just said I'm gonna ask that of you in class in the test. So now you want me to give you the answer.
Not a problem.
Okay, so think delict, right? There's an ethical relationship between the contractor and who's the other guy, the principal agent. In as much as there isn't a contract, he could sue for delict to say an action by you caused me to lose money, that loss or injury. And if he could prove that in intellectual terms, then he can recover the damages to say, this is how much I lost because you, in your position, acting on behalf of the client, you deceived me, and then I did things and I lost money. So that is where delict would apply. That is where he could sue.
Okay. In simple terms, does that mean the person with the best evidence or records will win?
Most probably. So in terms of delict, there's a case I came across. I downloaded it, but because I'm busy, and you just said I'm prof, and I did say, guys, I'm just a miss. Me, I'm not an academic like that. I'm not even doctor, so don't do that to me. I'm not gonna say I receive. I'm not even aiming for prof. So yeah. Anyway, there's a case I came across of a lady in a hospital. It's a delictual case. It has nothing to do with construction per se, but I thought it would be very interesting for you guys. I'll share it and I'll just call it the delict case, and then you can read through it. But what I want you to see from it is causation. You know, when we say the act, the loss, and then is there a link between the two? Because that lady loses the case because they're saying, yeah, we can see the loss, we can see the act, but we can't find the link. So in your words, the one with the best paperwork, and so with a civil case, it's more evidence than not. You know, with a criminal case, you have to prove beyond reasonable doubt that somebody did something. With a civil case, if you give us more evidence than the other person to believe your version, then you sort of win. So in that case, the contractor would really just have to prove. There is also, because the case I've cited is from the 1800s, and I really should just update my examples. So Polani says vicarious. So when you find Polani under delict, right? So you see, at least I see you guys know your stuff. Either you are engaged or you know these things, and the quite a number of accreditation, so it's probably those people. But yes, it does become who can present the effects better. So there's also a case where we were advised a school was built and the contractor built a hall. So he was doing a number of schools for the department. And I think there was a mix-up. There wasn't supposed to be a hall for that school, but he built it. And it was worth about 5 million. And then the department was refusing to pay, to say, show us on our drawings where we asked for a hall. Now, I joined at final account. When I joined the department in 2018, this project was in final account and there was this dispute. And I spoke to one of the people I trust to say, okay, who's a lawyer? What happens now? And he said, well, there's something called unfair enrichment. You're going to derive value from that hall. The school is already using it. You refuse to pay the contractor all because you didn't tell him to build. And I don't know how somebody built an entire hall and you're visiting the site and you don't see that there's something wrong. I mean, from when they do excavations, you kind of have to ask, comrades, what are you doing? You know, but the hall was there, it was built, it was used as a dining hall, which was sort of uniform to all the other prototypes for the other schools. And I think that's what confused the contractor. But then they were like, no, for that particular school, we didn't need a hall. And it was a dispute for a while. And they were suing for that. And then there was that thing, they introduced the whole unfair enrichment to say the department is benefiting, but they don't want to pay for it. Why would a contractor donate 5 million to government, you know, and stuff like that? Eventually we paid. That whole thing of acting in good faith, I think it never went to court. The agreement was, let's just pay, because then when they sat down and looked at how much it's going to cost, it's like, you know what, we can pay and walk away from this. And also there was savings somewhere. So there is that as well. And just back to your point, Tagazelo, it is, if the contractor can prove his case or at least provide more evidence than the architect. I don't know what the architect's, I keep saying the architect, the principal agent's defense would be in that instance. But yeah, the whole idea is then he can sue from a delictual perspective to recover. So that is of the answer I'm looking for. But I'm not going to ask the question in that manner in the test, but it is going to be there. Not this online test, the real test that you sit and write and we look at each other with who are those people, the invigilators. Any more questions? Okay, in the absence of okay, let's hear you. And then Tagazelo, you can follow soon after Tagazelo. Right, yes, Tagazelo.
Excuse me. Can you hear me?
You must be a project manager. I know those guys. Just when you think you wrap up the meeting, they're like, I have a question. Them and time, Shem. Okay, go ahead.
Hey, good evening, ma'am, and to the class and all my colleagues. I have an issue here, ma'am. I'm sorry I'm approaching it like a PM, but I can't access the class recordings. It keeps on saying access denied, so
None of the
um,
class members can. I did advise that Ms. Mapungwane said she will create a YouTube something and then she will share the link with the entire class. So obviously, because she's doing us a favor, we sort of have to wait for her. So I do not have access to the UJ network. I work on my own personal machine, so I don't have access to the server. So certain things I do not have rights to. And this is why I had asked her to create the calendar invitation so that and use you guys' emails so that people can access this thing. But it's a mess. I mean, ever since they introduced MS Teams, it has been very difficult. There was a time when I used to download these things and then share them, but it's a lot of admin for me to do that. I'll see if I can do it, I will. But the thing is, it creates a lot of work, and sometimes then I download and I share the link. And then after a while, it says enough people have downloaded and it stops being accessible. So I really don't know how it works. But yeah, with that, Shem, it's something we're still dealing with. I suppose if it's not sorted by the first term, you can escalate it to the HOD. I will not complain because I also don't know. I've complained about it for the past 3 years, I think, since they introduced the system, and we're not getting any joy. Initially, I was told by Moodle that I should not be recording the entire lesson. That's not the whole idea. And I just said, well, for some of my students, there's an issue with network. So yeah, I don't know. You can, maybe the more people complain, the more they will move faster in making the system better. Okay. So I
yes, ma'am,
can't assist.
can I offer myself to help out? Like, I don't know, maybe I'll figure out a way to work around it. But because this issue is not just with you, ma'am. There's
No,
also
it's
like a
not.
bunch of other
It's
lecturers
it's
as well. So
it's the system. So I don't know how you can pitch how you intend to help out, because like I say, in previous years you'd find that it becomes an issue because now I burden the class reps to be sharing this links and all of that, because like I say, I do not have access to the UJ system. I'm not connected to their network, so I connect remotely as a guest to set. So my rights are limited. Okay, so yeah, you can hit me with an email with regards to what it is that you want to do or what
all
you
right.
think you can help with. Okay. Um, Tuko, you have your hand up. I don't know. I think Tagazalo had his hand up initially. Or did I make a mistake? Tuko, you can come through, and then if Tagazalo still has something to say, he will say it.
Okay, evening, ma'am, and everyone. I wanted to ask, I'm not sure if I missed this, that since we are like classes are still ongoing, like for the test that we're gonna write next week, are we covering the work up until what we do this week or until where? And then the second question is, do you know if during test week, like, are we still attending while writing or is it just tests?
So generally, test week means no classes. You're writing tests. That's what usually happens. So I think isn't test week after next? Is it next week or the week after?
Next week.
Next
ma'am.
week.
Oh my goodness. Okay, so it will be with the work until no, but I'm not gonna make you write. You write in the last week. You close on the 27th, don't you?
Yes, but I think that I don't know when we're closing, actually. I
You
don't know.
close on the 27th, so that's the week you're gonna write my test.
Oh, okay.
Because like I said, it spans over. I can give you the entire week to write it. You know, you have a number of days to write it. The whole test week business, I give class during test week because it's slap bang in the middle of classes. And then afterwards, you write the test, and then the following week, we're supposed to sit again for class. That my brain doesn't work that way. So next week, we'll have class. And then that other week, then you'll have your break and you'll write the test. And then during the holidays, I'll mark. Okay.
Oh, okay. Then you'll advise us, like, as to we are studying up until this, I don't know. Yeah.
So we'll stop at guarantees and securities. Okay.
Okay. Thank you.
Tuko? No, it was Tuko. Then Tagazalo. Yes. Tagazalo, you can come through.
Oh, sorry about that. Just the last one on my side, ma'am. It just has to do with the presentation that you just given us. In regards to clause number 7, design responsibility, in a project where there's been so many changes in terms of the drawing design, so much so that it no longer speaks in accordance with the bill of quantities, but yet again, you're expected to do the work within the accepted budget. What happens in a situation like that, ma'am, where the design has changed in such a way that it's no longer in accordance with the bill of quantity? What happens in a project of that nature, or rather, how would you handle something like that? Thank you.
Okay, so basically the way the JBCC is structured, we work on a provisional bill, so a remeasurable bill, right? We have the bill of quantities that we remeasure as we go along. So it's not fixed unless in the contract we state that it's fixed, then it becomes remeasurable. However, if the design changes so significantly that it's now like a changed scope. So let's say you were building this very rectangular house, and then halfway through, the architects start getting ideas, and they say, with the dining room, we could change this wall to be sort of a curved wall. And then instead of plaster and paint on the outside, we can introduce that stone cladding, and then here we can put random. Those things have to be handled as variations. So you'll see when we deal with payment clauses, even with there's a certain amount of change, there's a limit to how many changes you can make in terms of amounts before then we say, okay, the contract value has changed. Because now if you I think it's 15%, I can't remember, because I deal with NEC and bespoke where I am. I could be lying, but when we do the payment clauses, it will show you in terms of how we deal with variations. But basically, unless the bill is fixed, you are entitled to payment for those changes. They should pay you and pay you based on the changes, the scope that you've implemented. The only thing with the JBCC and bill of quantities is that if you had given me a rate per square meter of brick wall, so let's say one brick wall, you say square meter is 495 per square meter, and we had agreed that we were going to build 100 square meters, but then I changed it to make it 180, you are tied to that 495 rate. Okay, but you will be paid for the extra work that you've had to do. So if the design has changed, obviously you when the design changes, you have to raise the fact that this is a change to what was agreed. Therefore, there will be a change to the cost, and you sort of present it. It can't be that they keep changing their minds, but you are somehow expected to be paid at the same. So for instance, like I say, if you're going to use Mampara bricks, then you would give the Mampara, this is your stock bricks, standard stock bricks, that's Mampara bricks. And then all of a sudden I'm like, you know what, I want facing brick here. So you have those people with their internal walls, they want exposed brick. So they will say, I want the red FBX facing brick, no longer Mampara brick. The rate is going to change. That's a variation. So that would be the case. It needs to be dealt with as a variation. I don't know the merits of the case you're describing, but it sounds to me like somebody's being bullied there. Mochizi, you have your hand up, and then soon after you, it will be Fortune. Tagazelo, did I answer you before I move on?
Yes, ma'am. But I'll be looking forward to that class where you're talking about payment clauses. Thank you very much.
Okay, so after Machizi, Fortune will come in, and then I'll answer both. Okay.
Thank you, ma'am. Good evening, ma'am, and class in large. Ma'am, I just want to do a follow-up question with regard to the remeasurable bill of quantity. So in case where maybe you are working with road or mining, I know that with building, if it's remeasurable, if the client or the consultant just give you more scope of work, I know that it might be exactly what he gave you. But with road work or mining, you might find out that the more you excavate, when you excavate 20, maybe 20 by 20, but when those plants come to do something, maybe when you are compacting, you know that your trench might go bigger. And yeah, it might go bigger. The more your plant do something on the trench, it might go bigger. So in terms of that, when maybe you are done and you have to submit your claim and the client start complaining to say, but this is not what we agreed upon, just because now you are working with measurable bill of quantity, and now the client is now out of the budget. He has exceeded his budget. What do you do in that case as a contractor, maybe?
All right. I will be sending an invoice for this answer. Let's just take Fortune's question, and then I will answer you. All right.
Thank you, ma'am.
Good evening, ma'am. Can you hear me?
Fortune, you're a bit muffled. I don't know if there's anything wrong with your mouthpiece. We can hear you, but it's like you put your hand on your mouth.
Can you hear me now, ma'am?
Yes, I can.
Okay, good evening, ma'am. Good evening, everyone. I just wanted to ask, I've been trying to figure out as to what is the difference between a variation order and a site instruction.
All right. Okay, so let's start with Mochiza's question. So Tagazelo asked last week, how do you know which contract to use? The scope of work determines what type of contract you use. So Mochiza, the sort of works you are describing are engineering works. JBCC principal building contract is not meant for those type of works. It's meant for building works. So if you think about buildings, there's a certain level of certainty when you're dealing with buildings. With mining, imagine trying to sink a shaft and using the JBCC for shaft sinking, right? You don't know what happens when you start digging. Because remember, we start with the ventilation shaft and then we start going. So like with your engineering works, you're better off using either GCC, FIDIC, or NEC, right? So if you're using JBCC for those type of works and a bill of quantities, you already have a problem. Especially a bill of quantities measured with the standard system. So when you're doing engineering works, we would measure using SANS, what is it called? Is it SANS 1200? For us, it was before it changed to SANS, it used to be SABS 0400 for us, but I know it changed. So you use SANS 1200, and that sort of specifies, because obviously with JBCC, if I dig 20 cubic meters of volume of soil, when I fill up that place, unless I'm creating a platform and I'm going higher, the understanding is I'm going to fill it up with 20 cubic meters. But when you're building a road, there's it's SANS 10400, yes. There's an understanding that you're going to compact and you're going to do this. And for some reason, the material, when you compact, may react I don't know if react is the correct word, but you may find that it becomes even more compatible, and then you have to keep on putting more. So in that instance, when you're doing those engineering measurements, we know there's a fair amount of contingency that you build in because there's a high level of uncertainty. So let's say you're building a road and it's a completely new road. So in the Eastern Cape, we decide we want to connect my grandmother's village, Mkemani, to Matatiel, because that's the closest town, right? Or is it Mount Elif? Yes. Or you want to connect Mkemani to Mount Elif. There's no road there. Very close to each other, but there's no road. First of all, you don't know what the soil conditions are there. So when you do your planning, you would have done your geotech and all of that. But once you start digging, you may find that there are certain things you missed. So there is, you expect those variations. Obviously, if your client is now skimping on payment because he doesn't have enough budget, then during the planning, something was not done right. There's a certain level of uncertainty that you have to allow. With building works, in real life, we only allow about 2.5 contingency. And this is when we've done the design, because everything happens on the surface. We don't go too much underground unless when you have to do your bulk excavations for 4 levels of basement and stuff like that. With building contracts, we sort of generally know what's going to happen because it happens on the surface. The minute we're out of the foundations, there's almost certainty, unless COVID hits and then suddenly we don't get material from China. So with building, there's a certain amount of certainty that we have, which we do not have when it comes to engineering works. So like I say, JBCC would be a terrible contract. However, whatever the contract is or the measurement tool that you used, it should make provision for those contingencies. And this is why, even if when you look at that sun system, you have excavations, which is that excavation in trenches, but how they deal with bulk excavations, like where you're creating your basement, they deal with slightly different. But even they doesn't make sense. Not sure if that brings you closer to the answer or not. However, as a statement from me, if the contract is not fixed and it's remeasurable, all the contractors prove that needs to be paid based on that. Okay. Are you answered? Okay.
Yes, ma'am.
Answered. All right. It seems I should proceed with the other clauses because you guys didn't want an early night. Lucanio has a question. Yes, Lucanio?
It wasn't a question, ma'am. It was just to assist with regards to the bulking, especially around civil works. So each layer usually would have a bulking factor. If it's a G9 or a G7, then those factors then allow you to get reimbursed for taking out that extra material. You might not get paid for the actual excavation, but your cutaway quantity then increases with that particular bulking factor, which is then always allowed for so that you get some money in compensation. It was just to add on your point. Thank you.
Thank you very much. I had forgotten what it's called, that factor you were talking about, and I kept on thinking, what is that? But thank you. Tadiwa? You can come through?
Yes, ma'am. Evening, ma'am. I just wanted to find out if the quiz, ma'am, will grade itself after we submit, or because I hear you talking about marking, ma'am. Are you gonna have to write, or is it just a multi what choice there, ma'am?
It's multiple choice, true or false. However, you have to apply a bit of thinking to it, right? We play with language a bit to confuse the enemy, and in this instance, the enemy is you. So it doesn't grade itself. I have to tell it to grade. It doesn't automatically do. So I have to tell it. So generally, and then, so it's with the click of a button on my side, and then I will release the marks. So you won't submit and then it grades. I don't set it that way. Any more questions? Sipo?
We're talking, is it an assignment or it's a test? I think I've missed.
It's a quiz. Ooh, Fortune had a question. I see now when he raises his hand again. It's a quiz, online quiz. It's not, but like I said, you have 3 days to complete it. Fortune, yes, sorry. I now have lost my trail of thought because you had asked your question.
Okay,
What was
ma'am.
your question again? Sorry.
No, I was asking
Oh,
about
side instruction versus a variation.
and the impact it has on the costings.
So a side instruction could end up being a variation depending on what the side instruction is, right? So generally a side instruction is, so for instance, we've given a design. I'll use an example of one of the buildings we're doing in Pretoria. We had put the generator in the basement, but it was then there was a mini sub right there. And the city said, you're not going to get a occupation certificate with this nonsense that you've done. This is a fire hazard. You can't have a generator and a mini sub next to each other. One of them has to be outside. So obviously the mini sub was moved outside. This is an old building and then we built a new one next to it. So we connected the basements and this is where we found this business of a mini sub in the basement. So now they said move the basement, the mini sub outside, and then they showed us a spot. So now you design a plinth for the mini sub, like a mesh concrete plinth for the mini sub. The contractor says, oh no, that will cost about, let's say, 32,000 to do the plinth. And then I will, the relocation of the mini sub will be this amount of money, right? So they will disconnect and do whatever, do the coring so that the wires move. However, then we realized that where we're putting the mini sub is right in front of a fire hydrant. So we need to change the location of the plinth. So at this point, the contractor has not built the plinth. It's just from the plan, the engineer will just issue a side instruction to say, instead of having the plinth and the mini sub here, please move them to this point. So that the side instruction is just to tell the contractor what to do in that circumstance, where there's uncertainty or there's a clash. It may not have a cost implication or a time implication, right? It becomes a variation if now it impacts either the cost or the time or both. So then it has to be reported as a variation to whatever was agreed. So not all side instructions will lead you to a variation, but at times you'll find that a side instruction will lead to a variation. So for instance, if for whatever reason, the contractor is saying, this is what you've specified, but actually those people have closed down, so that is no longer available. We need to find an alternative item for this. One of the designers, the engineer, the architect can issue a side instruction to say, okay, fine, do not use this anymore, use that, right? So this is to create a record for the contractor to say, I changed because there was an instruction for me to do. So it is to give credence to the change to what was originally agreed. And that change may have a cost impact or may have a time impact, because sometimes your variation, it could be that it doesn't increase the cost, but it's going to delay certain something, and I may not finish on the 5th of May, I'll finish on the 10th, type of thing. And the contractor says, look, I'll absorb the cost of those 5 days. However,
Ma'am, I think you're on mute.
okay, when did I go on mute?
Like 2 seconds ago.
Oh, okay. All right. I was
were
thinking
talking
I've been
about
blubbering and I was on mute. So what I'm saying is the side instruction is usually to clarify something to the contractor or just to guide them in terms of what to do. It could lead to a variation. It may not. It may not. So side instruction doesn't necessarily mean a variation, but there is a possibility that it could lead to a variation. Okay.
Okay, thank you, ma'am.
All right. Other questions? Before you change your minds, good night, guys. Let's do this again next Monday. Bye. Have a great week.
Good night,
Bye,
ma'am.
Mayan.
Bye.
Good night, ma'am.
Bye, everyone.